like my favorite is the dying declaration.
Yeah.
Like, the guy with one eye killed me. Like,
Yes.
like
which
that kind of thing.
rarely comes up in,
But it
in
has.
real life.
Yes.
I think I've come across it once.
But you assume the person who's dying wants the person who killed them to be caught, right? You
Yes.
assume if I was killed by Bita, I'm not going to say Karen's the one who did it.
I have prosecuted someone for it at trial and gotten him convicted for it, and it was actually his false statements was actually made in a family court case. But
yeah.
Maybe that's how you're done.
No, but I know the case that you're talking about, and that is like that extremely exceptional, right?
Yes, absolutely.
Yes.
Hello, everyone. My name is Karen Mishler. I'm a prosecutor at the Clark County District Attorney's Office, and today I'm hosting a panel on the questioning of witnesses. And joining me today, we have Judge Bita Yeager, Attorney Michael Burton,
Hello.
and Justice of the Peace Nadia Wood. And I'll let the three of you introduce yourselves further.
So I'm Judge Bita Yeager. I'm a district court judge here in our 8th Judicial District Court in Las Vegas, Nevada. Before that, I was a hearing master for the district court. Before that, I was a justice court judge. And before that, I was a public defender for 19 and a half years.
I have a much shorter introduction. Michael Burton, and I'm a family law attorney. I do primarily divorce and custody. Have a law firm, Burton and Reardon, with a business partner. And so for this particular topic with witness examination, I primarily, exclusively actually, appear in front of judges in bench trials only.
I'm Judge Nadia Wood. I'm a Justice of the Peace in Las Vegas Justice Court. I preside over preliminary hearings. Basically, almost every criminal case starts in front of the Justice of the Peace, and then if I find probable cause at an evidentiary hearing, then the case finds up to the district court judge, like Judge Yeager.
Yeah, and technically, she does actually bind up
I do,
over
actually.
to me.
Yeah, she's one of the judges I bind up to.
Yeah.
Well, we've received a number of questions from the public, and I kind of thought it would make the most sense to start with things that were very basic. So as we all know, at trial, parties put on their cases or they defend against cases through the questioning of witnesses. That's the fundamental aspect of a trial. So I thought we'd kind of start with a basic question of what is the difference between direct examination and cross-examination? Whoever wants to take that first.
Sure. So direct examination is done usually, vast majority of the time by the person that's putting on the case that bears the burden of proof. Direct examination, there's a difference between the types of questions that you can ask in direct examination and cross-examination. So in a direct examination, you cannot ask what are called leading questions that suggest an answer. That's done in cross-examination, and usually it's because in direct examination you're asking questions of witnesses who are usually favorable to you that are going to answer the questions directly to you. And then on cross-examination, the other side gets to question that witness. And because those witnesses are not favorable to them, they actually get to ask them the leading questions.
The best way I think I've ever heard it described is on direct examination, the witness is testifying. On cross-examination, the lawyer is testifying.
Right. Yeah.
Because you're telling the story, and if you do it tight enough, the witness is simply just nodding and being forced to essentially agree with everything you say. And half the time, even if he doesn't agree, if you're in the flow, it doesn't even really matter. It seems like he's agreeing, because you just keep going anyway. But so that's how I tend to look at it, is that, and that's why attorneys love cross-examination.
They do. And I think what I see most typically, or the most typical explanation, is like direct exam questions are what did you see, what happened next?
Open-ended,
And
right.
defense attorneys love to make fun of prosecutors. They say, well, in direct exam, all you're asking is what happened next.
Yeah.
And
And then
there's
what
more to
happens?
it, but it's like the who, what, when, where,
Right.
sometimes why, a lot of that. And then cross-examination is a lot of yes or no questions.
It should be all leading questions. It should be very tight, no room for explanation, and it should be expected that you're going to get pushback. You're going to have a witness who will not want to answer these questions in the manner that you're asking, which is the preparation. It is much more difficult to prepare a cross-examination than a direct examination because, again, on direct, you're just literally saying, tell me your story, and the most common question is, what happened next?
Now, there are actually some certain situations where when you're in a direct examination, you can start asking cross-examination type questions, because if the witness is what we call hostile, a hostile witness, someone that is, adverse to your case, right? Well, so yeah, direct examination is in, like, for example, in a criminal case, the prosecutor is putting on the case, they present the initial witnesses, they do the direct examination, the defense attorney cross-examines.
Right.
Right.
But
there
no
may-
leading questions in the direct.
So maybe,
Correct.
so maybe almost backing it up and going a little bit bigger picture, right? So in any case, criminal, civil,
Right.
whatever it is, each side gets to put on their case, right?
Right.
And so you've got the one side that goes first, and then the second side goes second. Usually it's the party with the burden that goes first, be it civil plaintiff or criminal prosecutor. But each side is putting on their case. And so when they put on their case, they are calling the witness. They do direct because it's their witness that they're calling. The other side gets to cross, and then when they're done putting on their case in chief, and the other side, if they want to put on a case in chief,
Right.
is putting on the case, then when they're calling their witness, the other side gets to cross. So everybody kind of theoretically gets a chance to cross and direct.
Right. And
with
just,
who-
yeah. And just to make sure, if the prosecutor in a criminal case or the plaintiff in a civil case is it's their case, they bear the burden, the defense side has no burden. So, so they don't have to
Right.
do anything. They could sit there like a lump on a log if they wanted to. They never do. But, it's important, I think, for the public to realize that the defense doesn't have to, like in a criminal case, prove that their client is innocent or anything along those lines.
Right. Or even do a cross-examination.
Yeah.
In that only leading questions, which are typically how cross-examination is done, that's only permitted on adverse witnesses, I guess is another important point. Or like
In a direct case.
right.
Yes.
Yeah. On the direct part.
Yeah, so if
Yeah.
you're calling a witness on direct examination, so that's actually correct. They don't have to be hostile, just adverse.
Adverse,
Yeah,
yeah.
so if they're
Adverse, yeah.
adverse.
Anybody
yeah.
called by the other side essentially is fair game for leading questions if their position is adverse, right?
Right, or if
Yeah.
you call them, but their position is adverse.
Correct, yeah.
Yeah.
And then, so Michael, you kind of brought this up. How do you go about preparing for a cross-examination of a witness?
Well, that actually would tie into another question that's on here about depositions. And you guys don't use depositions too much in criminal cases, right?
No.
Yeah,
almost not
yes.
at all.
But in
Yeah,
civil, they do it
yeah.
all the time. So I also have a civil docket.
Yeah.
So
So in regular civil world, they're pretty deposition heavy. Family court, where I practice, you have depositions are kind of a luxury. They cost money, and you're dealing with the public here, so everybody's budget's different. But if you can get a deposition ahead of time and so depositions, when I question somebody, an adverse party in a deposition, I'm not questioning the same as in court. I want him to tell me everything that he wants to tell me so that I can take it and truncate it down to these leading questions. And it's pretty laborious, but also family law is very motion heavy. So you have a lot of motions being filed during cases that are signed with declarations, affidavits under oath. So those are fair game, any statements in there. And you start tying. So the questions should be, something like, and then you did this, correct? And then after that, you've never once, called the police, right? And if they start to deviate from the answers they've given you in a deposition, now you have to the other question in here, what is a deposition good for? It's impeachment. You can now really hold somebody to their testimony. And so deposition's a great way, but also just reviewing, like I said, we're pretty motion heavy, but I think that's why in civil cases they do so many depositions, because it's not as motion heavy all the time.
So it might be helpful to our viewers to explain exactly what a deposition
Okay,
is.
yes. So
Okay.
a deposition would be when you call somebody in and the rules are basically the same as in court. They're sworn in, there's a court reporter there, and you get to question them. And there's very limited ability for the other attorney or other side to stop that as far as any sort of questions. They have to be completely out of bounds to not answer.
Well, and there's not a judicial officer there to make any
Right.
decisions about whether or not something should be answered or not based
So-
on the rules of evidence.
So you preserve your objections in the record, but the questioning still continues. So it's a great way to get your testimony under oath ahead of time, and that testimony is basically locked in and can't really be deviated from at that point without serious problems for the witness, for credibility, because the typical way I would use a deposition, just to kind of get into, we can kind of round out that question right now too is once I have it established, my questions from the deposition, then I would start by saying, okay, and then, you've only done X 10 times ever, right? And if they say, no, I've done that more or less or whatever it is, and then you start with, do you remember having your deposition taken? And do you remember coming to my office? And do you remember taking that oath? And then you start reading it to them, and then they say, okay. And then you usually do that like once, maybe twice, and then the witness is done playing that game. They don't want to do that anymore. They know, you just have to reach for it at that point, and then they stop.
And that kind of leads into what my next question was going to be, was what is impeachment? And I think, Judge Wood, would you like to take that? I know you would have done something similar when you were a defense attorney or a public defender, but you're not dealing with depositions. So how would you go about cross-examination and impeachment?
Yes, yeah. So yes, before I became a justice of the peace, I was a public defender for 11 years, and yes, did a lot of cross-examinations, and now I see a lot of cross-examinations because we have a lot of evidentiary hearings down in justice court. So for me, cross-examination at preliminary hearing, similar to a deposition, that you're going to ask more open-ended questions because, again, you want to get as much information as you can possibly get out of the witness at the early stage, because then when you're in trial, it's exactly what you're saying. So basically, impeachment is you've said something before, you're saying something different now. So I'm going to confront you with the thing that you said before. And what we call hard impeachment, and we have what we call soft impeachment or refreshing recollection, right? If you're being nice to the witness, it's not necessarily a witness that you're calling a liar, but maybe just, hey, maybe you don't remember. Would it refresh your recollection to take a look at your prior testimony? Versus if it's a witness that you're maybe accusing of not being completely truthful, then you can literally confront them with the statement and go, okay, that's interesting. So you lock them down first. So today you're telling me the car was red. Yes, you're 100% confident the car was red. Yes, okay, that's your testimony. Let's take a look at what you previously said. And you literally hand to them what they previously said. You take it over and you go, read this part silently to yourself. So 1 month ago, when you testified under oath, raised your hand, swore to tell the truth, you said the car was blue. Did I read that correctly? And I mean, it's in front of them. And so that's your classic impeachment, right?
And you've just reminded me of another cross technique that is used is when you really have somebody, every question should become 10 questions, So, if somebody in my world, let's say they're alleging some abusive conduct of child abuse, but they've never, let's say, called the police or reported it. That gets broken down to, so you never called Child Protective Services, right? No, you never called the police, did you? You never told the counselor. You never told the rabbi. You never, you want this you want the judge to just be like, all right, enough at that point. So when you have somebody to really kind of stick it a little bit, like this is a big point, let me just belabor this a lot here as to what you did or didn't do.
So at its core, impeachment is basically just using information through questions to discredit the witness. Mm-hmm. I mean, that's basically what you're doing.
It's basically, previously you said X, today you're saying Y.
Mm-hmm. And kind of that softer form of impeachment you were talking about, because you can actually impeach your own witness, right, even on direct, yeah, which you're definitely not trying to portray them as bad. You're not trying to portray them as untruthful, but a lot of the time witnesses don't remember.
Yes.
The number of times I've refreshed a police officer who's testifying, refreshed his recollection with a copy of his report because he doesn't have a photographic memory, doesn't remember exactly what time it was that he arrived, may have forgotten an address.
Yeah, that's like more rehabilitation, right? Mm-hmm. Like you're trying to not impeach him. You're trying to fix the unintentional impeachment, I guess, that the person just had.
Mm-hmm. And in Nevada, we don't have, so some jurisdictions require you to refresh before you impeach. Nevada does not require that. So you can pick, right? You can decide this is a witness who's, helpful to me and I just would like to gently refresh them. Or you can decide, this person's adverse. I'm not going to gently refresh them. And you can jump straight into the impeachment. There's no obligation in the state of Nevada to first refresh a witness before you impeach them.
I will say, as a general rule, people will use refreshing recollection in direct, and will use the impeachment portion, through prior testimony in cross-examination. But to just talk about from a trial attorney's point of view, there is definitely a strategy as to how you want to present yourself to the jury. because you most of the time the jury wants to they as much as you admonish them and tell them like you can't get your emotions involved in it, they want to they will look at you sort of with a critical eye if you're being really rude or mean to a witness. So I think for a trial attorney, they've got to take that into account.
Yeah, that's a good point. Another question from the viewers that I really liked, because it kind of made me think about how as lawyers we use this really weird jargon that doesn't make sense to a layperson, because what they asked was, what is a foundation objection and why is the foundation of a question important? And I think they're asking this question because they've seen an objection, like objection, lack of foundation, and wondering what does that mean? Like that's not really intuitive.
Yeah, and it's probably the second most common objection, maybe, or the first most, right? I would think relevance in this would be pretty high up.
Yes, I would think so. So, anyone want to explain foundation?
Sure.
Go
Well,
ahead,
I mean, so foundation is basically where having enough information before that witness testifies about how they received that information, how they are an eyewitness, or if they were the one that took the photograph, or those types of things. So you first need to be able to establish that that person has that first-hand knowledge, and that's where you get that foundation. So if they start going straight into testimony about stuff that you have no idea where they're getting this information from, that's where you might draw a objection foundation objection. So
putting the person first, whatever the subject matter, what they're testifying about, you have to put the witness there first, right?
Yeah, I mean, what gives them the basis to have that firsthand knowledge? What makes their testimony relevant because they know this stuff? That's basically how I would see it.
Yeah, like kind of in layperson's terms, right? If we're going to ask Judge Yeager what happened at my house on Thursday at 8 p.m., first we have to establish she was at my house Thursday at 8 p.m.
Right.
To then ask her, so what did you see?
And maybe why she was there, what she was doing there. A couple kind of basics that I think it's easy to not do these things in court because you become accustomed in life to just assuming a lot of things. But when you're dealing with something that's on the record and I think that's where they put these requirements that we have to check all these dots here. We got to put the person there. How do they know this? Why do they know this?
And I thought this was an interesting question. Why are witnesses disclosed in advance, and why are there exceptions to this with rebuttal witnesses? I guess we can start with the first half of that question, because I kind of thought, what kind of world would it be if we didn't have to disclose our witnesses?
Yeah,
like utter chaos.
Yeah, it probably would be. I think the whole principle behind trials is to give, there's notice, right? You need to give them advance information about the types of things, like in a criminal case, what the charges are, the types of witnesses, who the witnesses are that are going to be testifying against them. So that way, from the defense standpoint, that they have a fair opportunity to prepare. I don't know if anyone of our readers has heard the phrase trial by ambush, but that is something that, we will often hear like, hey, this shouldn't be trial by ambush, and that's certainly true. There should be enough advance notice so that everyone has a fair opportunity to prepare their case. And so that's basically why it's required under the rules.
And even, unless I don't deal with a lot of rebuttal type witnesses in my practice, but it's my understanding even rebuttal witnesses have to be disclosed, right?
Depends. Civil, it is. Criminal, it's a little bit.
In criminal expert rebuttal
Yes.
witnesses definitely have to be disclosed. They have to be noticed. There's case law on that where the state tried to just sneak in an expert rebuttal witness, and the courts did not like that.
But you're allowed rebuttal witnesses on the fly to contradict testimony if necessary for criminal cases?
Oh
Yes.
yeah.
Okay.
Yeah, I've had trials before where we put on our defense, and based on the information that our witness said, the state actually flew in someone from a prison that was, like 3 states over to discredit what had been testified to because they were the roommate of the person. But because, the truth of the matter is, especially in criminal cases, we don't do depositions unless like someone's dying or, that kind of a thing. And so what you find out in trial a lot of times is found out at trial. And so to give everyone a fair opportunity, they may not know that, we need to get this information from this witness to rebut because they didn't know what the information was necessarily going to be.
Yeah, and kind of backing that
Yeah.
up and taking it big picture, right? When we're talking about noticing witnesses, so on the civil side, there are depositions. On the criminal side, there's no depositions. That notice, so either side as an attorney is looking and saying, okay, I've been put on notice that John Smith is going to testify. You try calling John Smith up or showing up at his house and saying, hey, are you willing to talk to me? But it's completely his decision whether he's going to talk to that attorney or not. And so maybe you know what John Smith's going to say. Maybe you don't know what John Smith's going to say, just depending on whether he decided to talk to the attorney or not. And so there is a little bit more latitude
Right.
on the rebuttal side of things because we're not expecting the attorneys to know exactly what these witnesses are going to testify to versus on the civil side of things, you've had the opportunity to depose John Smith.
Right.
You shouldn't be surprised by anything he's saying at trial. Whereas it's entirely possible that an attorney can be surprised by what a witness is saying in trial.
Right.
In a criminal
And in
trial.
civil, you can make someone appear at a deposition.
Right.
Right? Like you
Yeah.
can force them to do
Yeah.
that. In criminal, you can't force someone to talk to you.
Yeah,
So-
in a civil case, if you depose somebody who is on a witness list, so anybody that the other side says, hey, these are going to be my witnesses, which they have to disclose, which is the crux of this question. And then the other side has the right to actually conduct depositions of all these witnesses. And if that person doesn't show up at that deposition, then they can't appear at trial. You can easily just strike them from participating at trial because they didn't participate in the deposition.
I will say, since I preside over both types of cases, in the civil world, they have a lot more information about what the witnesses are going to testify to than on the criminal side. Most of the time in criminal cases, you'll have like an arrest report, maybe an expert report, but it's a lot more. I mean, the amount of information that you go into the trial is much less than you would in
I
a
would
civil
bet
case.
that you have situations where the defense has people on their witness list and you have no idea necessarily until the day of what this person's going to do, and you have to kind of deal with that on the fly.
Yeah.
Yep.
Oh, you have that
All the time.
All
All the
witnesses on
time.
the prosecutor's list that you have
Yeah.
no idea what they're saying. Because realistically, because at preliminary hearing, right, the burden is probable cause, which has been defined as slight or marginal evidence. So the state's not putting on their whole case, right? They're calling one, maybe two or three
Yeah.
if it's a really sophisticated preliminary hearing. But usually you're maybe getting one witness that you're cross-examining at the preliminary hearing that you're hearing from.
If it's not waived.
And so it is truly at trial, if you've got a prosecution witness list that's 12 people, you've talked to maybe one of those people, and whoever's on the defense list, the prosecution probably hasn't talked to at all. And so it's
Right.
truly,
Not that you haven't tried to talk
yeah,
to them,
right.
right?
But
But
it's their decision.
yeah,
whether to talk
they
to
may
them.
just say like, "Go pound sand. I'll see you in court."
Yeah. And
Most
so,
likely, right?
Yeah. And so it's both the attorneys on both sides are oftentimes learning a lot in the middle of trial.
Yes.
Yeah, I would agree.
And now another question we had was, what is the exclusionary rule and why does it not apply to certain witnesses?
So either side can, what we call, invoke the exclusionary rule, meaning that if a person is going to be a witness in the trial, that they need to not be there during all the testimony. The purpose of that is so that they're not hearing what everyone else is saying during the trial, so that they could be like, yeah, exactly what so and so said. So it's really to have a little bit more reliability on what the witnesses are testifying to in the fact that they are testifying of their own knowledge and not relying on what other people said.
Yeah, and as to the exceptions, I mean, obviously parties can sit in the courtroom while other people are testifying, and then there are situations where experts do as well, because maybe part of their opinion has to do with it needs this information. What is being said? What are people alleging? Those are the only exceptions that I'm really aware of. Usually, you don't want people being influenced by what other people have testified to. It being even just biased, even if you're not it could even be unintentional, right? Like you could just hear someone else's testimony and it could just start to even affect your own memory maybe of an event. So I think it's to preserve the integrity of the testimony too.
Absolutely.
Yeah, you definitely don't want to exclude the parties, like civil or criminal. And then obviously, if you can't
Right.
kick a defendant out of
No.
their own trial,
Yeah.
that's a constitutional violation.
Right.
And I have done at least one trial where I had an expert, like my
in.
experts sat in to observe the expert testimony from the defense.
Yeah.
Because you can ask an expert, what was your opinion of this person's testimony? Did you agree with this? Did you agree with that?
Right.
Yeah.
Well, and I was going to say, just a lot of the times too, with experts, it's not just about their opinion itself, but also the basis for their opinion. What kind of methodology they use to get to their opinion, and experts will produce what we call reports that have their opinion, but they don't actually. You can't just admit the report into evidence. So it may become essential for example, like a rebuttal expert to sit in to hear what the testimony is. It may change slightly. So, and also attorneys can ask the experts sort of, if I were to give you these types of facts or this type of situation, what is your opinion on this? That might not be contained in the expert report, so that's why it's also something that would be essential for another expert to sit in so that they could, hear that when it's and comment on it when it's their turn.
Yeah, and kind of backing it up a step and going back to the whole point of the exclusionary rule is to ensure reliability, right? You've got lay witnesses who, like you said, can be influenced, right? I hear this other witness say the car was green, and now I'm going, was the car green? I think the car was green, and it's impacting maybe my memory, either deliberately or subconsciously, but we expect that that's not happening with experts because their opinions are based in the science, right? In order to be qualified as an expert, there are certain scientific requirements that what they're testifying to meets. And so our expectation is that one expert hearing another expert testify isn't suddenly, it's not changing his memory of something because his testimony isn't based on his memory of something. His testimony is based on
Exactly.
the science
Right,
and
the
things
analysis.
the analysis,
Right.
exactly. And so we're not concerned about experts being tainted by hearing testimony, whereas we are concerned with everybody else potentially being tainted.
Yeah.
Yeah, that's a good point.
I mean, that's part of the reason. I mean, you both probably admonish witnesses not to discuss their testimony with anyone else.
Yes. Yep, exactly.
So
Yeah.
exactly ensure that reliability.
Yep.
Right.
Yeah.
Never happened.
And that's a great point. Actually, yes, for the viewers, even when the witness isn't on the stand, when the witness is done testifying, I tell every witness, you are admonished not to discuss this, not just in the courtroom, but even outside the courtroom.
Right.
They're not supposed to be discussing their testimony.
Yeah.
That's a great point. Yeah.
Some other witness could actually overhear
Sure.
what they're saying.
Correct.
And,
Right.
Correct. Yeah.
or a juror could overhear what they're saying. And,
Yeah.
So moving on to subpoenas, when is a subpoena needed for a witness, and what happens if a witness does not appear? Subpoenas is something I dealt with a lot as a prosecutor.
Oh
doing-
yes, I
doing
would
trials.
bet that in my world we don't subpoena a ton of witnesses. Usually, the parties are the biggest witnesses in my cases of divorce or custody cases, and then usually people's witnesses that they are going to bring are going to be friendly. But occasionally, we have to subpoena witnesses and try to compel their appearance and have some sort of the subpoena creates some level of accountability that if the person doesn't show up, that there can be, the court can issue bench warrants or orders to show cause. What are the other things, though, Judge, is that that happen? Can you just make adverse inferences against somebody if somebody's subpoena doesn't show up? Does that ever come into play? As that if somebody is expected to be there, they don't show up for a subpoena, that reflects negatively upon one of the parties?
I don't know that there's any
Can.
sort of instruction.
There's a case that says that the party can argue it.
Okay,
There's a case that said basically if you would theoretically put your investigator on the stand either side and say, I issued a
Oh, right.
subpoena to John Doe.
And he still didn't
and
show up.
He still
right.
didn't show up.
Yeah.
And so then the party can argue it in closing, I guess.
As an inference.
As an inference,
But
yeah.
it wouldn't necessarily be like an instruction
No.
adverse
Yeah.
inference.
No,
right.
there's not an instruction that I'm aware of, but
Right.
it is, you can argue an
So-
inference. But just backing it up a little bit. So the subpoena is basically a document that tells a witness,
Right.
I'm trying to compel you
It's
to show
basically
up.
like a court order.
Yes,
You know,
exactly.
to say you have to appear in court. This is the day.
Yeah.
This is the time. You know,
It's not
yeah.
an invitation.
Yeah,
No.
yeah.
Yeah.
It's
You
like
have
you
to-
need to be here.
Yeah,
right.
So an attorney on either side, again, going back to everybody gets to put on their case in chief. And specifically in criminal cases, the Sixth Amendment gives defendants the right to subpoena witnesses. And obviously the state has the right to subpoena witnesses to put on. So everybody gets the ability to compel witnesses to come in so that they can put on their case. So that's what that subpoena is. It's that document telling a witness, hey, I'm compelling you. Like you said, it's not an invitation. You're supposed to show up.
Yeah.
There's precedent for people being subpoenaed to Congress and not showing up and being put in jail for this. So like,
Oh, it happens
yeah.
in criminal cases all the time.
Yeah, I was going to ask, have you ever done a contempt proceeding regarding someone not responding to a
So I
subpoena?
haven't done a contempt proceeding, but you know we've had situations where like the district attorney has been advised by the witness that they're not going to show up and that kind of a thing. So then we may have a hearing regarding that. There may end up being a warrant issued, you know, that kind of a
material
thing.
witness
Yeah,
warrant.
material witness warrant.
But what about if it's a victim?
They still issue them.
They still will issue
Sometimes
it.
it's
Oh,
not
yeah.
it's not ideal.
No, it's
We-
not ideal. I mean,
for
you know, you
sure.
sort of, yeah, like you don't want to start out with the witness being really mad at
Well,
you know,
or
you, but
throw a domestic violence victim in jail.
I know
Oh, they
that,
do it
that
all the time.
happens.
Yeah.
all
That
the
would
You,
time.
actually
you
probably the
avoid
most common.
avoid it as much as possible, but
Yeah.
in those specific cases,
Right.
it happens.
And sometimes, you know, what might happen is, for example, the person is saying that they're not going to show up, but they've reluctantly shown up in court before the witness warrant gets issued, and the court will admonish them like, hey, you need to understand that you need to be here on such and such a date and time, that you need to be here tomorrow. And if you don't, I may issue a bench warrant, so make sure that you are shown a witness warrant. So it just depends on the situation. You know, I think there are certain times also where the circumstances surrounding why the person doesn't show up is also relevant. For example, if it comes to find out that the defendant, the criminal defendant, has persuaded someone not to show up, right? That might come into play as far as other statements that could potentially come in that witness previously made. That avoid the confrontation clause. Like there's a lot of different remedies that the court is given great leeway to give.
But generally, you need the witness, and that's why you're subpoenaing. Like in the criminal world, like these people are often critical, right? Like even if you have
Sure.
police reports,
Yeah.
and I think that's the clarification that people need to know is like, no matter how documented things are with the police and reports and maybe even other witnesses, if there's not a victim there really who's going to say this happened to me, that's a big problem, right? I mean,
Yes.
like
Yes.
a critical problem. And so I think, so that's kind of what I think we're talking a lot about here is when that's the issue, right? When you have to really try to put the hammer down someone to come because you can't make this
Yes.
case without
Right, you
this.
can't you
Right.
can't just present someone's witness statement, or I mean that's a hearsay issue. You have to have live testimony. It's not fun. Most people don't enjoy like having to come to court and testify. It's not something they're used to doing.
Yeah.
It's
Now,
essential.
I will say in civil cases, I have had certain situations where a witness has come in with their attorney to quash the subpoena because it's overly burdensome because of a certain situation. There are certain things that a person can do to actually ask to quash the subpoena. Quash meaning like to get rid of it, that kind of a thing. So there are other ways that someone can actually deal with a subpoena.
But not showing up is not the right way, right?
Correct.
Definitely
Yeah.
not the right way.
Yeah. Yeah.
Definitely not the right.
They can challenge it through like the motion to quash, but yeah.
I do want to bring up the situation, like sometimes a witness has been subpoenaed and you're expecting them to show up and then suddenly they're not there. And sometimes that happens like through no fault of their own.
Sure.
That can happen.
Car broke down or, whatever,
Yes.
right.
Yes, I once had a witness show up to court late because she'd had some sort of automotive accident and ran like screaming into the courtroom and like thinking she was going to be arrested.
Right.
But we do have remedies for that situation. Typically, the prosecution will ask for a continuance or maybe ask for a recess to figure out like that's something that can happen. We'll do motions to continue if we're surprised by the non-appearance.
Yeah,
of the
and
witness.
the other thing too, and this is probably a little bit more in civil cases, that the court also has great leeway to take witnesses out of order if there's like a scheduling issue or, like you said, like someone got into a car accident. We were planning on having this person next, but can we have them tomorrow instead? So there are different ways to work around
We
it.
definitely do that a lot in family court as far as witnesses out of order. Anybody that's professional pretty much at all will be given priority because most of the other witnesses are just lay witnesses.
Right. And now moving into one of my favorite topics, what is hearsay?
Oh, hearsay.
Who wants to go first?
I will, because I think there's those important distinctions in the definition, because I like this topic as well. So it's an out-of-court statement. So something said outside of court that is trying to be admitted into court for the truth of the matter asserted, which I think is the most key part of hearsay, because it goes on that if it's not admitted or sought to be admitted for the truth of matter asserted, it can be admitted for any other purpose. And there's a lot of other reasons why hearsay might be admitted if you know the rule and know how the rule functions well and can get past the truth of the matter asserted and understanding fully what that means. Is there an area that attorneys struggle in more than understanding than hearsay as far as an evidence rule?
I don't think so.
Yeah, I think hearsay objection is probably the most common objection that I will ultimately see, and knowing the different exceptions to hearsay, whether the declarant needs to be available or non-available, or whether it's non-hearsay. I mean, there are so many different exceptions and they fall under different, so unless you have a really firm grasp on that, it might get a little hairy. In fact, I have a cheat sheet that I have with me just to make sure, because I'm like, wait, is that non-hearsay or is that right? Because it can get very detailed as far as like figuring out which
becoming
exception.
well versed on this as a practitioner can make a big difference and set you apart from other people, because you will be able to get testimony in that other attorneys wouldn't be able to get in that aren't as well versed in the area, and knowing. Usually it comes down to the truth of the matter asserted and trying to latch onto that to try to get exceptions. I'm bringing this in for other reasons, and just finding one of those reasons. I've been accused in court before of being overruled on these objections and having other attorneys say, but he's just backdooring things in through other reasons. But that's our job, is to do that, is to find if it doesn't work this way, maybe it'll work this way, not just give up. So I love hearsay too, and trying to find ways to
A lot of
get around
people
it.
get really tripped up by the fact that they skip over the fact that it has to be offered for the truth of the matter asserted for it to be hearsay. And some people think that means you can't bring any sort of out of court statements in, and that's obviously not the case. You couldn't.
And the truth of the matter asserted would be if somebody made some statement that say this person is this or did this, that you're actually trying to get the statement admitted to prove that specific thing happened or is true. And that's not the case a lot of times. A lot of times you're doing something else. Like in my case, I'll give a good example, which would be in my practice area, where if somebody has called the police or child protective services for some reason, and we have to explain that, and I say, okay, so then why did you call? And essentially part of it is my child told me something. And so my child told me this happened and this happened and this happened at maybe the other parent's home. Okay, so I'm not trying to admit it to prove in court that those things actually happened. That's the truth of the matter asserted. I'm trying to provide context to what my client's actions were and explain why he called these people. Otherwise, if I can't provide context, then you don't understand what he was doing or why he was acting the way he was. So I think that is a very common way to use it, is to provide additional context, but then we have all the built-in exceptions and stuff.
Yes, we have many, many exceptions.
And all of the exceptions are kind of, when you go back to it, rooted in indicia of reliability, right? Because the entire idea is, are we going to allow you to admit this to prove that it's true? The exceptions, while there's all these detailed lists and all these things, what they tend to go back to is, okay, in this particular circumstance, does it make it more likely that the thing that was said was the truth? One of my favorites that I always kind of refer back to is the statement for purposes of medical diagnosis, right? Because everybody kind of grasps that one and understands that one, right? The idea being, most of the time, people, when they're explaining to their doctor how they ended up with the injury, are telling their doctor the truth because they want to receive adequate medical treatment, right? And so there is an inherent, not saying they're always telling the truth, but we as the law have recognized that probably they're more likely to be telling the truth because they want good medical treatment. They don't want to lie to their doctors and end up getting a medication they shouldn't get, or getting a surgery they shouldn't get, or something because they've been dishonest. And so all of the other...
I was going to say, a lot of the exceptions, there's an incentive built in for that person to be telling the truth. You know, like someone wouldn't necessarily say something that's completely against their interest, like, oh, I totally robbed that guy, right? Unless it was actually the truth, right? So things like that, you know, this is all based in like English common law from like the 1800s, but you know, back then, all those, you know, attorneys figured out like, these are the types of statements that probably are reliable. Like, you know, my favorite is the dying declaration. Like, oh, the guy with one eye killed me. Like, you know, like
which rarely comes up in,
but it
in real life. I think I've come across it once.
But you assume the person who's dying wants the person who killed them to be caught, right? You assume if I was killed by Bita, I'm not going to say Karen's the one who did it. I'm going to identify the person who actually killed me.
There's one that I don't see on your chart here, but makes sense as well, is like the contemporaneous, when somebody is contemporaneously telling you about something. So if they got you on the phone.
Present sense and present
impression.
Yeah, there. It's present section.
He's stabbing me.
Right there.
He's stabbing me.
Right. Like if somebody's narrating something to you that is happening live, that is probably fairly reliable. But I on here as well is the catch-all, which I think this is where you go when you're out of ideas. But and it basically says that if the nature and special circumstances under which it was offered offer assurances of accuracy. So even if it qualifies as hearsay, if however it's being presented, if the judge determines this would be lead to accuracy, it could be admissible under that catch-all.
It could, yeah. I don't see that as often. I mean, it's usually one of those sort of well-established exceptions that we'll usually get.
Guys agree that judges are pretty careful about hearsay as far as...
Yes.
Oh, yeah. I would.
Because you want to make sure the information that's coming in is accurate. And that's the whole point of hearsay, is trying to limit things that can't be verified for accuracy.
Right. Now, I will say, like, there's also a strategy as far as making objections and whether or not an attorney is going to object to certain things, even if it is hearsay, right? It may be a situation where it might be hearsay, but they don't really care, so they're just going to let it in because they also don't want to look like they're being obstructionist in front of the jury. So
plenty of times that it doesn't hurt you.
Yeah, that's true.
I'd be sitting in trial and I was like,
okay, I don't
that
care.
doesn't hurt me.
Right?
That's fine.
Or it might provide a cross-examination point then, like, okay, so now you want to talk about that, so we can talk about this now.
Yeah. So I guess I just wanted to say that, you know, while there are objections that happen in trial, just because you can make an objection doesn't necessarily mean that the attorney will or should.
Correct. Yeah.
Very true.
Yeah.
And I think another thing that sometimes people miss about hearsay is that it doesn't just apply to live testimony. It applies to documents. Like I was saying, that's why you can't just admit a police report. But
still a statement.
Exactly.
Yeah.
It's a statement. It's
Yeah.
just a statement
Yeah.
on paper.
There's like a
Right.
whole section of law on what's a statement too, as far
Correct.
as
Yes.
signals and all these other things.
Correct.
Yeah.
Yep.
And when I was a prosecutor in the fraud unit, I got very used to the exception for
Business records.
What we call it's
Yeah.
it's technically called a record of regularly conducted
Right.
activity,
Yeah.
but we
Right,
all
right.
call it the business record exception. And-
Right.
But it's similar. There's indicia of reliability. You're looking at a receipt or an invoice. Like
Right.
generally, companies are going to do these and make them accurate.
Sure,
And
because
so-
I mean they're gonna,
Yeah.
their taxes or whatever are dependent on
Things compiled by the government, for example.
Sure.
Like when they're doing their reports and their data compilations. In my world, Nevada has this thing called Nevada Report Card or something like that, and it's an accountability thing that Nevada does where they rate their schools, but it's through the state of Nevada, and that is fair game in court as far as the business record exceptions. But I can't go to like a website. They have websites called like rateschools.com and stuff where people, parents get to rate websites and make commentary. That I can't do anything with because that's full of hearsay, but this government analysis is total fair game.
Yeah. Is that coming in through the public records exception?
Yeah,
Or is it-
basically, there's one about, I don't think we have it on here. There's one that has to do with government tabulated data, and there's so many of those periodicals and these other things that can qualify.
learn treatises.
Yeah.
Learned treatises, yeah.
Yeah, there's
Right.
there's ancient documents,
Yes.
even though that just
Yeah.
means more than 20 years old.
Yeah.
Yeah.
And that's related to hearsay, at least in criminal cases, is the confrontation clause, which is it's weirdly intertwined with hearsay. So who wants to talk about what the confrontation clause requires?
Gonna do it?
Sure,
Okay.
yes. So the confrontation clause is, it's a very big one in criminal. And it's basically that the defendant has the right to confront and cross-examine the witnesses against them.
It's based on the Sixth Amendment.
Yes.
That you have that right.
Yeah, it's rooted in the Sixth Amendment. And fun little factoid, the entire concept of hearsay is actually also rooted in the confrontation clause. That's where hearsay comes from. And so the confrontation clause kind of has a two-step analysis. The idea being, again, you have the right to confront the witness. So if the witness isn't present, we were talking about earlier, for example, the victim, who's like your necessary witness, then the judge has to conduct this two-step analysis. Step one, if the prosecution's trying to get in a statement of a witness or victim, step one is the statement hearsay? Because the analysis dies if it's hearsay, right? You don't even get to the step two, was it testimonial or not? So you start with, is it hearsay? If it's not hearsay, if it's actually an admissible statement outside of the fact that the witness is not here, even with the witness not being present, it would still be admissible. Then there's the second analysis that occurs in criminal law, which is, okay, is this violating the defendant's constitutional right to confront the witnesses against him? And then that becomes an analysis of whether when the statement was made, at the time it was made, was it testimonial in nature or was it non-testimonial in nature?
Right.
Because again, going back to reliability.
Right. And the whole thing, I guess the whole basis of the confrontation clause is, you're in front of a jury, right? And they're the ones that have to be able to see the person, to assess their credibility, and then the defendant has the right to start testing that person's statements by cross-examining them. So really, they are testing out in front of the jury and showing whether or not that person is credible. And that's part of it. Also, like the confronting part, like I'm looking in your eyes, like you can't lie to me type of thing, where, that's part of, again, based way back in like the English common law, but that was sort of the theory of if someone is lying, and people have tells and those types of things, you have the right to be able to sort of demonstrate that by confronting them and cross-examining them and letting the jury assess if they're potentially lying.
I think that is super important. We've all seen direct testimony. Anybody can deliver really convincing direct testimony, where you just go, wow, this person is cooked. And then
the cross comes, and then you find you have, like you said, the poking. We're going to start poking through this, and things maybe don't look so good after that. So that's really a part of it too, is that people's stories and statements need to be tested, because it's very easy to tell a one-sided story that's super believable, appears credible, and we've all seen it fall apart, where you're like, this seems locked up, and then all of a sudden one thread comes out, another one, and this is all coming apart, and at the very least you've poked significant holes in something, and I think that kind of ties into, yes, you have a right to confront, but confrontation also can lead to the truth. Really, that's what we're talking about. Find out what happened here, and to do that, there has to be both sides participating.
The adversarial nature.
Right.
And then, so another aspect, so sort of the next step from what you were talking about when you get to testimonial hearsay, there is a way to admit that evidence if the declarant is no longer available and there was a prior opportunity for cross-examination. Most of the time that won't be the case, but the most typical example is someone has testified at like a preliminary hearing or a deposition, something where they were subject to cross-examination, and since then they're no longer available, and you can bring in their statement for that reason. I've had that happen because I was on fraud and elder abuse, and so a lot of my victims were elderly. So an elderly woman testified at preliminary hearing. By the time the case had gone to trial or was set for trial, she had passed away, but she had testified, she'd been cross-examined, and so her prior testimony was just admitted.
In civil cases, when they have elderly people, they will often do depositions of their own clients, because if this person passes away, I need to get this testimony locked in now. And it's weird, you don't usually depose your own client, but they do in those cases, I understand.
And that moves into the question, we talked about depositions a little bit before, but one of the questions was, why are depositions needed if the witness is going to testify anyway? And you basically answered it primarily for the civil realm, that you're deposing as a discovery device, a way to get information. In the civil realm,
It's a way to get information under oath, so you get all their story, like we were talking about before, getting letting, this is where you want to know everything that they could say or would say, and then it becomes a trial prep tool. So you get the testimony, so you know what's. I'll say this too. When somebody deposes my own client ahead of time, I don't mind it, because I learn all their strategies too. Because by the questions they're asking and the angles they are going, I know, oh, this is where you're putting your energies on, and then I can prepare for that. And it's really good if my case in chief is first, I know all their angles, I'm gonna get ahead of this over here. I'm gonna start asking these questions to my client, get any of these explanations out that I need to get out. So removing the impact of somebody else being able to trying to cross my client, because that's what they're gonna try to do, is do what I was saying earlier, come across my client, and I wanna try to head that off and use my own client's deposition and their revealed strategy to prepare my client ahead of time.
And sort of the way depositions are used in the criminal context is sort of the opposite, because you do that to preserve testimony. Have either of you done depositions in criminal cases?
I haven't. It's usually so rare. Like you said, like if there's like an aged victim, like an elderly victim, or someone is incredibly ill, right? Like someone has cancer and they may pass away or something like that, then they'll move the court or ask the court if they can do the deposition. But other than that, I really haven't seen it done.
Very rare.
Yeah, it's pretty rare.
So I've done a few depositions, again, because I dealt with elderly victims, but because and you actually have to, like you said, you have to file a motion. So you have to ask to be able to do a deposition, and you want to depose your own witnesses because you're trying to preserve that testimony. Yeah. So and they 70 years old is the cutoff. Like that's one of the reasons you can request to depose, or if someone has an illness. So I've done that for that reason. But it's very different from a civil deposition, where because in civil you're not in the courtroom.
Yeah.
Right.
It's a, sorry, go ahead.
Oh, no, and she was saying that, she had to ask permission. So that's strictly criminal. And civil, this is an absolute right. You have a right under the Nevada Rules of Civil Procedure to conduct depositions.
Yeah, it's part of discovery, but it's in the criminal realm. It's kind of odd because you're basically trying to do trial, but specifically just for everything you need to get out of that specific witness, and you do it in court in front of a judge. It's just it's like a fraction of a trial.
Right.
And criminal, the prosecution cannot compel the defendant to speak either. So there's that difference too, where in civil you can depose the opposing side and find out what they're going to say, which in criminal that would be the defendant and he doesn't have to say anything.
Right.
And in criminal, the depositions only get used if by the time of trial the witness is no longer available.
Right.
So just because you did the deposition doesn't mean you get to use it.
Yeah.
And so I thought this was an interesting question, and I don't really know how this would roll in the civil realm, but someone asked if it's discovered after the trial that a witness's testimony was inaccurate or untruthful, can a new trial be held? Who wants to tackle that one?
Well, in criminal, yeah, I mean, it depends. I mean, they have to do it within a certain time period. Sometimes if there's no way that they could have known, I guess that could potentially affect their the time period in which they could potentially ask for a new trial. But yeah, if it is something that is a critical issue, for example, you'll see it oftentimes like in post-conviction relief. For example, in criminal cases, oftentimes you'll get testimony of a snitch, right? Like someone who is like their roommate or something, and maybe they get a benefit by testifying favorably for the state, and then later on you found out that that person like totally made up what they were saying just to get that benefit. And if that person was the crucial witness, I would think, that would be enough for the defendant to get a new trial.
How does it work in the civil world?
I do a lot of civil or family law trials, bench trials. I haven't had, this would be like Rule 59 probably or something, like motion for new trial or one of these. And they are time limited, but sometimes there's exceptions to time limits when fraud's involved. So I'm not very well versed on this rule and the ability to do this, to get a new trial if a witness lied. But when you have, as the judge alluded to, new evidence is always something that can come into play, but there still could be time limits with this. But this isn't something that comes up a lot in my practice either.
Mm-hmm. Yeah. And I guess it's kind of a different situation in criminal, because you'll have somebody who's they're serving a prison sentence. They have nothing to do but try and fight their conviction. Sure. They might find somebody, try and convince them to recant, something like that.
I think questions 11 and 12 on the questions that were submitted are kind of telling to me a little bit about. One is if it's discovered later that if a witness lied, can a trial be held anew? And the next one's about perjury. And I think from the public's point of view, they think that there's a lot of lying that goes on in court, and
I don't know.
Very well, there are definitely moments where people lie, but people are more honest in court, in my experience, than you would expect. I think most people have a really hard. You can tell even that someone shows up and he wanted to lie, he intended to lie, but he couldn't do it because he's on. Now there are people who have no problem with this, of course, but the most people do have a problem with it. And then in my practice area of family law, which is very personal, and we get into what's a lie and what's just a different interpretation of things. So that's a kind of. So in some of these questions are maybe rooted in that people in my practice always think everyone's lying, and I get asked about perjury all the time, and I'm like, just stop. This is family law.
If I can jump ahead a little bit, I think that's maybe one of the things I think a lot of times, right, one side or the other, particularly parties, are very much like, that's a lie. You've got to call them out for lying. That's a lie. I think people don't realize how hard it is to prove that somebody's actually lying, because there's so many reasons that a story can change or be inaccurate, right? I mean, we're constantly...
Their memory may be wrong,
yes,
so they're not lying. That's what they believe.
Yeah,
right.
Yeah, like lack of accuracy versus lie are two different things. And I think that
to really be able to actually prove lie is an incredibly high standard.
Intentional lie.
Yes,
Yeah.
intentional lie. That's an
Right.
incredibly hard thing to do. It's a lot easier to prove lack of accuracy sometimes, right? Because
Sure.
it could be, let's watch the video. You said X, here's what the
Right.
video shows.
Right.
But again, it could be your memory, right? I mean, anybody, we always talk about the classic game of telephone, right? The same conversation gets repeated 4 times, and by the end of it, it's a completely different conversation. It's not that anybody's deliberately trying to lie along the process. Maybe they are, but I think that's a thing that parties particularly get very hung up on. That's, I think, a little bit more nuanced when you're, as an attorney, what can you actually prove?
And also, aside from proof, just the perceptions, because sometimes it's just perceptions. Like, you two are perceiving things differently, so therefore you perceive this person is being untruthful and all these other, but you're just not looking at things the same way, which is not that uncommon.
Yeah. And a lot of times, listen, trying to prove that somebody's lying is a burden you don't need to take on, right? For either side. Again, now if it's a situation where you're asking for a new trial and you're trying to say, listen, this person was dishonest, that might be a different situation. But a lot of times it's, at least me as an attorney, I was like, I don't need to prove they're lying. I just need to prove they're not accurate,
Right.
right? It doesn't matter whether they're deliberately not accurate or not. The point is, they're not reliable, and you can't, back when I was a defense attorney, you can't convict my client, or vice versa. If it's the prosecutor, listen, it doesn't matter why this witness isn't accurate. The point is, you can't rely on this testimony. You got to rely on my witness's testimony, whatever it might be. It's when you start getting into that word lie, I think it's a really difficult thing, and not necessarily a thing that you need to be tackling. Whereas the people who are really personally involved in it, you absolutely understand, right? The parties, the defendants, the victims, they're hung up on that, right? That person's lying. And a lot of times I think they get confused why their attorney isn't as hung up on it as they are. And it's
Right.
because we know
It
we
may
don't
not
even-
make a difference.
we don't need to go
Yeah.
there.
I
right?
try to talk my clients out of this, and because a lot of times the materialness comes into play too. Like, they get hung up on because when something's personal to you and it's like your case, your life, you will hang on every detail, or oftentimes you will, and then you're hanging up on every lie, and you're like, these things aren't even material a lot of times. So that's probably why they're inaccurate, because it's not even that material to the other person. They don't have a reason to have some sharp memory on something. So this actually makes me kind of laugh, just because I deal with that a lot.
Sure.
And I think some people get confused between like perjury and impeachment, because we've been talking about impeachment. That's just pointing out inconsistencies. Again, that doesn't mean that they committed
person lies.
Right.
Yeah.
Doesn't mean they're committing perjury.
Yeah.
Perjury is a crime that someone can be prosecuted for.
And how often, just for my knowledge, so I can pass this to my clients when they ask me this question, how often are people charged with perjury in Nevada?
Not often, although ironically enough, I have prosecuted someone for it at trial and gotten him convicted for it, and it was actually his false statements was actually made in a family court case. But
Yeah.
that
Maybe that's what you're talking
No, but I know the case that you're talking about, and that is like that extremely exceptional, right?
yes, absolutely.
I do know the case, because that's how exceptional it is.
Yeah.
It's,
I haven't
you know,
seen a perjury case.
Yeah,
go
I've not
through.
seen one.
Yeah,
Yeah, not many.
that's what I expected to hear.
Yeah.
Yeah.
Not many people have done it, but it was just someone was being very public about his family court case, which caught the attention of the police, and
Yeah.
so he started investigating, and then realized, wait, when this person testified about his income at this hearing under oath, he testified that he had no income. And then, we look at his employment records, we know that's false.
Yeah.
And it's not something that could be a simple mistake. He literally said he had no money, so that's perjury. And then another thing a lot of people, I think, kind of forget is.
Well, and by the way, usually on the financial stuff, they sign it under penalty of perjury.
That's exactly
right.
what I was.
So that's the other thing.
That's
too.
exactly what I was going
Yeah.
to say. That was the other count of perjury was
Right.
because in family court you fill out these financial declarations. I mean, and we fill them out a lot. I think we fill them out when we get a driver's license. You sign something under penalty of perjury. That
Right.
you can
That's
be
the
prosecuted for perjury for that. Just
Right.
signing.
When
your
you were in the
name.
frauds unit, did you deal with that at all, where you prosecuted people for perjury because they had done fraud in a manner that had them fill out things under penalty of
Yes,
perjury?
I think I did prosecute someone. There was some sort of issue with the driver's license application. It was perjury for signing something under declaration perjury.
But I would imagine even things like maybe bank loans or financing where you're attesting to your income, that could be maybe fair game. But I
Those are
think
usually, from what I've seen, forgery or fraud
Oh,
charges,
okay.
right? Very
Yeah.
rarely do they go under the perjury theory
Okay.
when they've got these other theories that they
Right.
can go under.
Okay.
Yeah, compared
Yeah.
compared to something like forgery or a material fault or a false statement, something like that.
Yeah.
That's going to fit the behavior better and make more sense to charge that.
okay.
And I guess the last thing about perjury, I think the questions kind of indicated people were kind of confused about how it matters whether it's a material statement or not. And I kind of, because I think people are saying, well, if somebody says something that's untrue under oath, like that should automatically be perjury or something like that. But if somebody like says that they're a year younger than they actually are,
Right.
it's
Or
not
they
really.
drank Diet Coke, but it was really Pepsi,
Who
right?
cares? Like,
Yeah.
it's not,
Yeah.
like
Yeah.
that's not related to any material issue.
Yeah,
Right.
this is meant for the professional liar, basically. The person who is going to court with the
Yeah.
express purpose to mislead the court and to create a false narrative or to protect themselves in that way. I think that's what people need to focus on, and not individual statements that people make that they might be able to show that technically aren't true.
Any
that wrap it up?
any final thoughts?
No,
Alright.
nothing from me.
All right, I think we're ready to wrap things up.